Hi everyone, we're gonna get started in just a minute here, but my clock still says 6:29, so we'll give people as long as we can to log in. We'll get started in just a minute though. Hi everybody, good evening. Thanks for joining us for the Citizens Law School. My name's Anna Ketchkage. I'm an attorney with the Department of Agriculture. I work out of Helena. And thanks a lot for joining us for tonight's version of the Citizens Law School. If you joined us last year for Judge DeSoto's presentation, um, thank you again for volunteering. But tonight's her topic is a little bit different than last year's conversation. And so we're really thankful and excited that we get to have some insight into the federal judiciary. I'm Anna. I'm just here to introduce Judge DeSoto, and then I'll be moderating throughout the evening, which is mostly looking for if there's questions. If you have questions, please feel free to put them in the chat. Just with the kind of general disclaimer that Judge DeSoto would love to hear your questions, and we would encourage you to do that, but she can't answer questions about specific cases that are before her or might come before her. So um, the only thing I guess that's the only disclaimer that I would have. Please feel free to ask questions, though. We would welcome those. And just as kind of a way of a brief introduction to Judge DeSoto, she went to the University of Santa Clara for her undergrad degree, and then she got her law degree from the University of Montana. And she practiced at a law firm, the Garlington firm there in Missoula, for some time before she took the bench in 2019. And so, again, thanks for volunteering and thanks for joining us, Judge DeSoto. And yeah, I'll be letting you know if I see any chats come in.
That sounds great. Thank you very much. I presume everyone can hear me okay. I already said this to Anna. Tech is not my strong suit, and I was able to put together a PowerPoint, and that pretty much tapped me out for my technological abilities. So if anything goes amok in this, I'm going to have to rely on the help of others. And I do want to echo what Anna also said about questions. I have a presentation that talks about different issues relating to the federal judiciary and the Constitution, and some of it's just general background stuff. But certainly, if you have questions about anything that I'm talking about or the types of things that federal judges do, while we can't get into specifics, we can talk about general. And so I'd be more than happy to answer any questions that you might have. So the federal judiciary and the Constitution is a really broad topic. And when I was asked to speak on this topic, I wasn't sure exactly how to structure it in a way that I think would be sort of helpful. And so what I did was sort of break it down into kind of different sections. And the first section, if I can get my PowerPoint to work, where do federal judges come from? And that's a pretty basic question, but actually it's not very commonly known, I think. And so just kind of going back bigger picture, the US Constitution is obviously the basis of our government, and Articles 1, 2, and 3 of the Constitution form the basis for the three different branches of government. So Article 1, this is just the balance of powers. Article 1, that is the article that sets out the legislation, and so, or legislative branch, I'm sorry. And so it creates a Congress. The Congress has a Senate and a House of Representatives. Section 8 of Article 1 sets out the powers. There's a lot more than I put in here, but these are sort of the big ones. Borrow money, regulate commerce, make money, constitute tribunals inferior to Supreme Court, and I'll talk about that more in a moment, and make laws necessary and proper to carry out the powers. So, making laws, that's what the legislature does. Article 2 is the article in the Constitution that creates the executive. And it says the executive power is vested in a president. It sets out the electoral college process, and then it sets out the powers of the executive, including making treaties, nominating ambassadors and judges, issuing executive orders, granting pardons. There are some other powers as well, but those are the highlights. And then Article 3 really is where the judicial branch comes from. And it basically says that the judicial power of the United States is vested in the Supreme Court and in such inferior courts as the Congress may from time to time ordain. So the Article 3 literally just creates the Supreme Court, and then it gives guidance to the Supreme Court about inferior courts, as Congress may from time to time ordain. So there's interaction between all of the different branches in relation to judges. So judges of the Supreme Court and inferior courts hold offices during good behavior. And what that literally means is lifetime appointments, unless there's not good behavior, and then folks can be stripped of their judicial positions. Section 2 of Article 3 is the granting section, and that grants powers including all cases in law and equity arising under the Constitution, federal law, and treaties. So just sort of thinking big picture, remember this is the federal Constitution, so it doesn't create courts in states. In states, they have their own constitution. They have, all the states have their own branches of government. They set up the courts as they choose. And so Article 3 of the US Constitution really only sets up the federal courts. And it's just important to remember that. So shortly after the Constitution, the Judiciary Act of 1789 was enacted. And it really is one of the first things that our Congress did when it met. And that established the inferior courts and set out judicial functions. It created the Office of the Attorney General, a United States Attorney for each federal district, as well as the United States Marshal. So the Judiciary Act really is sort of the legislative basis for the functions and the powers that the federal courts have. So these are the federal courts. Start with if you think about this as sort of a pyramid, at the top is the US Supreme Court, next is the US Court of Appeals, and following that, the United States District Courts. So the US Supreme Court is made up of 1 Chief Justice and 8 Associate Justices. And cases come to the Supreme Court in a couple of different ways. More often, cases come to the Supreme Court through the federal court system. So a case starts in a US District Court, goes to a Court of Appeals, and then it goes to the US Supreme Court. However, sometimes cases come to the US Supreme Court from state Supreme Courts, and that's when they involve federal constitutional questions. And there've actually been a number of United States Supreme Courts that originated from Montana, and one was just argued last week, and that had to do with boy, if I'm remembering it correctly, the party's name is Case. So it sounds funny when I say the case is Case, but the party's last name is Case. And it involved what law enforcement, what flexibility does law enforcement have when they are at a person's home and there is a reason to go in without a warrant, but not a criminal reason, sort of like a well check. And this was a case that I believe originated out of Anaconda, and it was just argued last week. And that came up through the Montana Supreme Court. So it's not unheard of for state Supreme Courts to be the court through which US Supreme Court cases come, but it's definitely more common that they arise in the federal court system. The way you get a case to the United States Supreme Court is through a petition for writ of certiorari. So basically it's a petition, is just a document that asks the court if it would consider a case. The petition itself doesn't argue the meat of the case or the real issues in the case. It's explaining why the US Supreme Court should consider that case. And that's important to keep in mind when you look at the next little bullet point there. About between 7 to 8,000 petitions are received by the Supreme Court each year, each term, which is a year, and about 80 are granted. So, that's not very many. And so obviously there has to be a particular reason that the US Supreme Court would want to hear a case. And that can really vary. Sometimes there are what we call circuit split. So sometimes there's different holdings or different rulings from different courts, and it's a little inconsistent. And so a party will ask the United States Supreme Court to step in and make it clear to everybody what the law is. And the reason that's important is that the United States Supreme Court is the highest court in the land. So when the United States Supreme Court issues an opinion or makes a ruling or does something, all the lower courts are bound by that ruling. And so we have to follow it. So when you have circuit splits and the court accepts a case and decides to determine what the appropriate law should be, then that provides guidance for everybody else. And so that's, sometimes those are the types of cases that the United States Supreme Court will take. So the next little column there is the United States Court of Appeals. There are 13 appellate courts, 12 regional circuits, and the federal circuit. And I have a map in the next slide that will show that. But Court of Appeals are different than trial courts, and they are reviewing something that already happened at the lower court level. So they review procedures and decisions from the district court. They want to make sure that the proceedings were fair and that the law was correctly applied. So did the judge get the law right? And were the proceedings fair? Were the rules of evidence appropriately followed and things like that? It's important to understand that appeal courts do not hear new evidence. They do not have juries and they do not retry cases. So when a case goes to an appellate court, the parties will argue for whatever their, respective positions are, and then the court will determine what to do with that case. But it doesn't retry the case. It doesn't get to substitute its own judgment for the trial court's judgment. If the court is wrong on the law, they will instruct the court that it was wrong on the law and send it back to redo. If there was an issue of fact that was so clearly erroneous that it has to go back, they will instruct the district court on that. But they don't try the case anew. It's not a do-over or start over at the appellate level. They may send it back to the trial court and say, trial court, you have a do-over, and you retry the case. But that's sort of a different function between a trial court and a court of appeals. United States district courts, there are 94 federal judicial districts, and there are lots of districts have multiple divisions as well. So for example, Montana, we're a very large geographic state, but we are not very large from a population point of view. So we are one district, even though we're one of the larger states. But there are divisions within Montana. So for example, I'm in the Missoula division. We have a Great Falls division, a Butte division, a Helena division, and a Billings division. And so even though we're one district, we have different divisions. District courts have bankruptcy courts that are attached to them as well. And district courts are found in all 50 states. They're in the District of Columbia, Puerto Rico, the Virgin Islands, Guam, and the Northern Mariana Islands. And if you look at this map, and I apologize, it's a little fuzzy. I tried to clean it up as best I could, but these are the circuits. And so you can see Montana. If you could read that, I'm not sure if you can, it's pretty blurry. Montana's in the Ninth Circuit, and it's basically the western half of the United States. And then you have the 10th Circuit, which are our immediate eastern neighbors, the 8th Circuit, 7th, 5th, and so forth. And so these are the appellate circuits and how they're divided. You can tell, I'm not sure if you can tell, if you can see from the screen. So for example, California, you have these little dotted lines. These are the different districts. So you have the Eastern District, the Southern District, the Northern District. Um, Texas has multiple districts. New York has multiple districts. Pennsylvania has multiple districts. Many, I don't know if it's most, but many states have multiple districts, and then divisions within those districts as well. Okay, so it's focusing on the United States District Courts because that's where I am. And actually, let me finish this and then I'll pop over to the magistrate judges. So district courts are primary courts of the federal court system. And what I mean by that is that they hear cases first. And we have jurisdiction over almost all types of federal cases. There are also two special trial courts that have nationwide jurisdiction. And think of it like this: it's really it's subject matter that is, I guess, it guides these two special courts. Court of International Trade, that handles international trade and customs issues, and the Court of Federal Claims. The Court of Federal Claims is for money damages against the U.S., takings cases involving the United States, disputes over federal contracts, and other types of cases. But so those are two trial courts that they have jurisdiction over, all of the United States and the territories, whereas we only have jurisdiction over the cases that are in our district, Montana. So you may be asking, I didn't see magistrate judge anywhere on these slides so far. And so magistrate judges, which is what I am, are, if you remember, Article 1, Article 2, and Article 3. Magistrate judges are considered Article 1 judges. And what that means is that we were created by Congress. In 1968, Congress enacted the Federal Magistrate Judge Act, and it basically created these positions. Prior to, and I think the formal bankruptcy court was created in 1978. Before that, the district court and the bankruptcy court used a variety of different methods to have help. And usually they were called referees or commissioners, and these folks would be hired by the federal court to, help with some of the work and take care of some of the responsibilities. For the magistrate judges, it was formalized in 1968, and for bankruptcy, formalized in 1978. So I do not have a lifetime appointment. I have a term of 8 years. It's a renewable term. And what I do is different between the criminal and civil. So on the criminal side, I cannot preside over felony trials, even if the parties agreed to that. So I cannot conduct a trial, and I cannot sentence a felony case in federal court. But I can do all the other things on the criminal side. So magistrate judges handle arraignments and initial appearances. They handle detention hearings, preliminary hearings. I handle changes of plea, where the parties have to consent. They just sign a form that says, I understand I have the right to have my change of plea taken by an Article 3 federal judge, but I'm consenting to the magistrate judge doing it. That's pretty common in our district, at least. So those are the sort of responsibilities or the things I'm able to do on the criminal side. On the civil side, I can do all of the cases. So and this is kind of going inside baseball, but there are some cases, usually involving election issues, that always go to district court judges as opposed to magistrate judges. But other than that, if the parties consent, I can handle any federal civil case. And we have a process at the beginning of a case where the parties are asked if they want to consent to a magistrate judge or not. If they don't consent, it goes to an Article 3. If they do consent, it goes to me. So on the civil side, pretty wide range of types of cases that a magistrate judge is able to handle as well as a district court judge. So for criminal cases, another question that I think comes up a lot is who decides where cases go? So, most people are familiar with the state court system on some level or the other, whether they've been in federal or in state court or not. But most cases in Montana will be in state court. And that is true of both civil and criminal cases. So criminal cases in federal court arise from 18 United States Code 3231, which just says federal courts have jurisdiction over all offenses against the laws of the United States. So we have Title 18, Title 21, Title 8, a number of parts of our United States Code, which is just United States legislation, that sets out the crimes against the United States. So typically, a lot of the ones that we see here, at least, drug distribution, firearm violation, wire fraud, tax fraud, aggravated identity theft comes up, child pornography, some of those types of cases are in federal court as well. Those are the main types of cases that we see, at least here in Missoula. Now, federal courts also have jurisdiction over certain offenses committed within Indian country, and that's the language from the statute under 18 United States Code, Section 1153, and we refer to that as the Major Crimes Act. And so there are certain offenses that are prosecuted federally. There's a whole, I don't even know how to describe jurisdiction on Native American land. It's very complicated, both on the civil and the criminal side. But under certain circumstances, federal court will have primary jurisdiction over major crimes if they're enumerated in that statute. In the Missoula division, we don't have a reservation that participates in this. So we never have these types of cases in front of us. The other divisions, Great Falls and Billings, do. And so they have a number of cases that fall under 1153. So what kind of civil cases do federal district courts hear? So federal district courts are courts of limited, not general jurisdiction. And the reason that's important is because there's limited ways you can get in federal court. Most civil cases are going to be in state court. And we had a seminar here that we put on for teachers every couple of years, and we had it last week, and I did a presentation on civil cases, and I asked the crowd, have any of you been involved in a civil case? And nobody said they had. And then I said, well, has anyone gotten divorced? Oh yeah, there have been some divorces. Well, those are civil cases. Work comp cases are civil cases. There's a lot of cases that the federal court will not have jurisdiction over that are handled in the state court. Either, work comp's going to go to the work comp court, but just regular civil litigation is handled by the state court system. And the number differential is pretty staggering. The thing about limited jurisdiction is, by definition, it's going to limit the case numbers that you have. So our case numbers are very different than the state court system, which have just an overwhelming number of cases, criminal, civil, dependent neglect, cases of that type. So that's one thing, one key difference between federal and state court is it's only under certain circumstances are you able to bring a case in federal court. And these are the ways that you can do it. The first is federal question cases, and this is found at 28 United States Code, Section 1331. Those are cases that arise under the Constitution, laws, or treaties of the United States. The second is a diversity case, and that is found at 28 United States Code, Section 1332. So a diversity case is when there is diversity of citizens, so meaning not from the same state, and the amount in controversy is greater than $75,000. And the third is cases involving the United States in its sovereign capacity. So what is a federal question case? So a federal question case is when the basis of the lawsuit is a federal law or federal constitutional provision. So if you're suing under anything arising out of Montana Code Annotated, that's not a federal law, that's a state law. If you have a wrongful discharge act case that you bring, You might be in federal court if you can show diversity, but that's a lawsuit that arises out of a Montana statute. So by definition, it's not going to be a federal question. Examples of federal question cases include civil rights litigation, patent copyright litigation, antitrust litigation, so the Sherman Act, and claims questioning the constitutionality of a law or regulation or a program. So civil rights litigation is probably, I've had a patent case since I've been on the bench, and I've had antitrust cases. But they're not very common in Montana. At least I don't see them very often. Civil rights litigation is very common, I think, in all states. And civil rights litigation, generally, it's going to arise under 42 United States Code, Section 1983. So you might hear people shorthanded as a 1983 claim. And that's basically when you say that, somebody has violated your civil rights. Those are very common. And occasionally we get claims that question the constitutionality of a law or regulation or program. But I think civil rights litigation, if I had to guess, I would say it greatly outweighs the other federal question types of cases.
So Judge, when you say civil rights litigation, are you talking about like discrimination cases, or what do you mean when you're talking about
Yeah,
civil?
it can be. It can be. I think I have a slide. Yeah. Yeah. Let me go back.
Oh, sorry, I didn't realize you
Oh,
had a
actually,
slide
I
in the
don't even
back.
know. Now I'm gonna have to, let me see if I can go back. I'm a couple, let's see, there we go. Yeah, so
Oh, if you're getting
the
to it,
civil rights
sorry, I didn't.
litigation, so like alleging that a person's constitutional rights were violated by a state actor and alleging that a law or regulation violates the United States Constitution. So the constitutional rights are violated by a state actor. So, things that are the types of cases that we see, alleging excessive force by law enforcement, or it's not just law enforcement. It can be school districts or teachers or some kind of state actor. So a state actor means that they're employed by or in the course and scope of their employment with a political subdivision of the state. And so political subdivisions of the state include cities, counties, commissions, school districts, water districts, um, hospital districts for those rural hospital districts, things like that. Um, so so those are the types of litigation that we see. I mean, when I was in practice, I handled a lot of not a lot. I did some work in the school setting. And so, for example, when there's an incident on a bus, for example, or something happens in the school setting, and there's an allegation that an employee either did something or failed to do something, and by doing that violated somebody's constitutional rights, that would be a 1983 claim that would get brought. Law enforcement, unreasonable search and seizure, excessive force, things like that. Those are pretty common that we see. Then the second is alleging that a law or regulation violates the United States Constitution. So, procedural due process, substantive due process, equal protection, commerce clause. I'll talk about these in just a second. But those are ways that we see constitutional issues come up in federal cases. And this might be a good time to sort of put it in context. Most of the cases that come up that I handle, at least, don't have constitutional allegations. It's personal injury cases involving members, people of two different states, things like that. So these are really important issues, and it's important to understand them. But I would not say that necessarily on any given day, the majority of cases that get filed have constitutional allegations in them. All right, so here, this is a little bit more specific on the civil rights litigation. So what 1983 says, it authorizes cases when a person or entity acting under the color of state law deprives another of rights, privileges, or immunities secured by the Constitution and laws. So the first thing you have to prove to even walk in the door is that the entity or the person that you believed did something wrong, you have to establish that they were acting under the color of state law. So that's the first thing that you have to do. And then the second is that you have to establish that a constitutional right has been violated. So there's lots of things or situations that people are not happy about that they feel they were wronged by, and it should be there should be a remedy under the law, but it's not always going to fall under the umbrella of civil rights litigation. So if somebody did something to you, but they're not acting under the color of state law, that's the first, you can't even go forward because it has to be somebody acting under the color of state law. Sometimes what comes up is, occasionally we'll see things where there's a 1983 allegation in a lawsuit, but it's a private person. So if it's a private person, you don't clear the first hurdle, so you can't bring that 1983 claim. Doesn't mean you might not have other claims. It just wouldn't be a 1983 claim. And then you also have to establish that a constitutional right has been violated. So you can act under the color of state law and do something that maybe needs a remedy, but it might not be a constitutional right violation. So it could just be negligence, for example. So you do something, you have a duty, you breach that duty, you cause some damages, the person's going to sue you, but that might not implicate a constitutional right. Common cases that we see, like I said before, excessive use of force, violation of search and seizure rights comes up, violation of the right to privacy, free speech, failure to provide adequate medical care. That arises sometimes in the prison setting or jail. When somebody is incarcerated, there's an obligation to provide adequate medical care. And if somebody feels that they haven't, that is a case that we will see that gets brought here in federal court. And then challenges to the laws themselves. So the Fifth Amendment states that no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment incorporates that and applies it to the states. But it started with the Fifth Amendment. And there's two different kinds of due process, substantive due process and procedural due process. And procedural due process, I think, is a lot easier of a concept to understand. And when I was getting ready for this today, I was, doing some research, and some of the most prominent legal commentators will say things like, substantive due process is incredibly difficult for anyone to understand. I'm like, oh, okay. Well, let's see if I can sum that up quickly then. It's a really hard concept. And I remember taking con law in law school and really struggling with what it means exactly. But at its very most basic level, substantive due process protects individuals, so individual liberty, against certain government actions, regardless of the fairness of the procedures used to implement those actions. What that really means is that substantive due process is going to protect your liberty against the government, even if they observed all of the right process, the procedural due process. So that could have been, completely fine, procedural due process, check, but they still have to make sure that your substantive due process is protected. Procedural due process, as you can tell, that's the procedure itself. So it requires the opportunity to be heard at a meaningful time and in a meaningful manner before a liberty or property interest may be infringed. So if you think about it, and I don't think Montana con law has been covered yet, correct?
No, Constance Van Clay is gonna cover that one, I think,
Okay.
November 19th.
Okay. Well, and I'm not trying to steal her thunder. I'm just trying to maybe give an example that I think a lot of people are aware of. So we have what we call sunshine laws in Montana. They're constitutional. Pretty much every state constitution, I think, has some form of sunshine laws, but it's basically the right to participate and the right to know. So you get to know what your public officials are doing. You get to be notified before they do something so that you can comment on it and participate in the decision. So it's process-based, not outcome-based. So when there are, violations of the open meeting law, for example, if there is in fact a violation of the open meeting law, the governmental entity might have to go back and have another meeting, but it doesn't dictate the outcome of what's decided at that meeting. It just requires a certain amount of process. And that's what procedural due process means as well. So it's not outcome based, it's process based. And the two of them really, sometimes you have issues relating to both, sometimes you only have issues relating to one, but when you have both, they kind of work hand in glove together. So substantive due process, and another disclaimer that I should make is these are very sort of truncated explanations of things. There's a lot more to all of the things that we're talking about here today. This is really just an overview. And there are so many cases nationally at every level, trial court, appellate circuit, and Supreme Court, that discuss these issues. And if it was easy, we wouldn't have so many cases probably, because it would just be so apparent. But these are really difficult, complex legal concepts. And so I just wanted to have that little disclaimer before I talk about substantive due process. So the first step in a substantive due process analysis is identifying the constitutionally protected interest, because that's important. If it's a fundamental right, you have heightened protections. And so the scrutiny that the court applies, meaning what is the court going to do when it looks at it, is going to be higher, stricter. A fundamental right is one which is so rooted in our tradition of conscious of our society that without it, neither liberty or justice, that should be nor justice, would exist. So, fundamental rights, the right to privacy, the right to free speech, the right to, exercise religion. These rights are very important. They're found in the Constitution. And so that's, those are kind of the easier ones because they're constitutional based. So if it is a fundamental right, the government action is sustainable, meaning it's appropriate only when the infringement of the right is narrowly tailored to serve a compelling state interest. So what does that mean? What that means is that whatever the government has done, whatever the particular law is, it's only going to be appropriate under substantive due process analysis if whatever the infringement that results from that law is as narrowly tailored as it can be to serve whatever the compelling state interest is. So it's really a balancing act where the court has to say, and the government has to come in and say, well, we know it's an infringement of this right. We have a compelling interest in infringing that right for whatever reason it is. And we have made the law as narrow as we possibly can to serve that compelling interest so that we don't accidentally scoop up, kind of bring in a lot of other infringement that we don't need to do in order to serve that state interest. So there can be a lot to that analysis. You have to look at the law. You have to look at what the compelling, is it actually a compelling state interest? It's not going to be compelling just because the government says it is. They have to prove and establish that it is a compelling state interest. And they also have to prove that it's narrowly tailored. Because, it's pretty easy to write a broad law. And, you just make a very general law. And on one level, maybe that would be appealing because you think, well, it's very broad, and that way we want to make sure that we cover as much as we can. But if it's infringing a right, you don't have the ability to do that. You have to narrowly tailor it so that folks whose, either folks whose rights shouldn't be infringed or the scope of the infringement of the right is as small as it can be to make sure it's still, achieves whatever that state interest is. So it's a real balancing act, and it can be very, very tricky. But it's, we see those types of cases when legislation is enacted that folks feel infringes a right. They file a lawsuit, and then the court will apply the law to the best of its ability. with the Constitution, of course, being primary, and then looking at the legislation with the lens of the substantive due process analysis.
Yeah, I think you kind of said this earlier, right? But if we're looking at a substantive due process, if we're looking at the state's interest, this is going to come up most often if they pass a law or there's some sort of action on the state of on the behalf of the government, right?
Yes.
We're not looking at an individual's behavior to say, does that comply with?
Yeah, these aren't, again, this has to be the government. So like, well, you know, my brother can't violate my due process. He's not a state actor. He's just my brother. So I can be very angry at him and not be happy with something that he's done, but there's not a due process claim that would come out of something like that. It really has to be a government actor, a state actor of some kind. Um, so mostly, like what I was just talking about, like that last little bullet point in that slide, a lot of those types of cases are challenging legislation enacted by, the state legislature or if there's yeah, I mean, I guess usually it comes up in the form of legislation. I suppose regulation as well. I don't know that I've seen that because the regulatory process is so different than the legislative process. But most of what we see is challenging a statute. Okay, so if the right's not fundamental, the government action is sustainable as long as it's rationally related to the legitimate government interests. And so again, this makes sense because the more fundamental the right, the more protective we are of it, right? And so the government's not going to be able to infringe a fundamental right unless there's a compelling state interest, which is really a big state interest. But if it's not a fundamental right, then as long as it's rationally related to legitimate government interest, which is obviously a much lower level of scrutiny that the court will apply to the law. So figuring out the kind of right that we're talking about is really the first thing you have to do when you're talking about a substantive due process analysis. So procedural due process. First, you ask, what is the interest that will be affected by the government action? Then what's the risk of an erroneous deprivation of that interest through the procedures used and the value of additional safeguards? So what's the interest that will be affected? What might be affected if the government does something? What's the risk that I will have that interest taken away or in some way encumbered because the procedures they have aren't sufficient to provide notice to me? And then what would the value be? So what would happen if there were additional safeguards that were put into place? And then what is the government's interest in the procedures, including the function involved, the fiscal and administrative burdens of additional procedures? So, when we talk about procedural due process, like I said, it's not the outcome that we're looking at. It's what did you use to reach that outcome? What was the process that you used to reach that outcome? And for example, we need to have notice of certain things so that we can participate in certain things. So if a law was enacted and it didn't go through the regular channels, somehow it just became a law and the public wasn't allowed to participate in the lawmaking process, you might say, well, I think that's a procedural due process problem because, we weren't allowed to speak on that law. Maybe the law changes something, well, most likely would change something or enact something different than that was there before. And so my interest was taken away and I wasn't provided notice that might even happen. How hard would it have been to put out a public notice saying we're going to have a hearing on this? I don't think it would cost that much. I don't think it would be difficult for you to do. And in relation to the right that, that was either encumbered or completely taken away, when you balance that out, you should have provided more process. And so it's a really flexible analysis, and it's going to be particular to the case at hand. So, it's kind of think of it as a sliding scale. So, the risk of an erroneous deprivation, if it's a big risk, probably more process is necessary. If it's a very little risk or the deprivation or encumbrance is very small, maybe less process would be required. What the court has to do in those situations is look at all of it and then determine if there was a procedural due process violation. Equal protection is another constitutional argument that we see often in cases. And the equal protection is found in the 14th Amendment, and it prohibits states from denying any person equal protection of the law. And what that basically means is governments can't enact laws or take actions, do things that treat similarly situated people differently. And so the 14th Amendment was enacted after the Civil War, and it's been much more broadly applied and interpreted since then. But if you think of it at just sort of a real simple level, you can't discriminate against people. Laws must be both facially equal and as applied equal. And what that means is sometimes there's a law. Let's say there was a law that said, is on its face clearly discriminatory. So people with blue eyes cannot run for office in Montana. Oh, geez. What's the basis for that? Why are you doing that? That doesn't seem fair. So you could read the law and say that's probably a problem. But it's not always that obvious. Sometimes laws are facially equal, but in action, so as they are applied, they are not equal. So you may have a law that looks like it doesn't discriminate in any way, but when the law is actually applied to people, however the law is enacted, whatever the law is, it has the result or the outcome of being discriminatory. So those are two different ways to make an equal protection argument. And I've had cases where they've had both, and I've certainly had cases where it's just one. But those are two different analyses that the court will sometimes face. So similar to due process, what's at issue governs or guides or determines the level of scrutiny that the court will use when determining whether there's been an equal protection violation. So strict scrutiny, again, is the highest. Cases involving what we call suspect classifications, such as race and national origin, or cases impacting a fundamental right. So again, if it's a fundamental right or a suspect classification, the government is required to show a compelling interest that the law is narrowly tailored to achieve. So one thing to keep in mind when we talk about all of these things is that, you can have a law that treats classes or groups differently that can survive strict scrutiny if it is a law that has a compelling interest that the law narrowly, that the law is created or drafted in such a way that it narrowly is able to achieve whatever that compelling interest is. So, just because strict scrutiny is the highest doesn't mean that there aren't laws that are able to pass the strict scrutiny analysis. Intermediate scrutiny is sort of the middle road, and that's cases involving gender classification. And in those cases, the government must show that the law serves an important government interest to which the law is substantially related. So, again, the more fundamental or suspect the classification or right, the higher the protection, the higher the scrutiny that the government has to clear. Intermediate is, like it says, just in the middle there. Then rational basis scrutiny, the law is rationally related to a legitimate government purpose. And so just like in the due process analysis, substantive due process analysis, if it's not a suspect classification, as long as it's rationally related to something that's a legitimate purpose of the government, it's going to survive an equal protection challenge. So those are those are really the issues that I thought would be helpful to talk about in terms of constitutional issues that come before the court, um, that we see fairly frequently or fairly regularly. Certainly this does not cover all cases. I've had cases involving challenges, saying that this law violates the Commerce Clause or things like that. And so, there are a lot of different types of constitutional cases that we see, and it's going to really depend on what the facts are, what the right that the folks allege has been violated is, and that will kind of guide how the case goes forward after that. But I think that's probably a pretty good overview of the type of constitutional cases that we see, and also sort of giving you an overview of the fact that we are a constitutional court, meaning derived from the Constitution. I don't know if there are any particular questions. I can talk a little bit. I think we have quite a bit of time. Well, we have about 11 minutes left. I can talk about sort of the processes. I mean, the Constitution in action is what we do every day. So, for example, when I do initial appearances and changes of plea, the things that you have to handle at an initial appearance, for example, is making sure that the person, this is the process that we have to give them, making sure that the person is.
And you're talking about a criminal case, right?
Yes, a criminal
Initial
case.
appearances and arraignments.
Yeah. So if somebody is charged in federal court with a crime, they come to the magistrate judge and we have an initial appearance and an arraignment. And it's the first time, I mean, they will have seen the indictment, which is the charging document, but they are advised of their rights and they are advised of the maximum penalties that can be imposed upon them. So they have constitutional rights. They have the right to, maybe I could probably get rid of my stop sharing. Yay. Folks have constitutional rights, and I advise them that they have the right to remain silent. They have the right to have an attorney present. They have the right to have the warrant presented to them. They have the right to have the indictment read to them. I advise them of all of these rights. I advise them of the maximum penalties that can be imposed upon them. So that's really kind of the Constitution in action, and we do those hearings almost every day. And then at changes of plea, most changes of plea in federal court, at least in Montana, have a plea agreement, a written plea agreement. And the written plea agreement it sets out many, many things, but there are multiple paragraphs that sets out all the constitutional rights that the person who is pleading guilty will waive by entering a guilty plea instead of having a trial. And so if they have a written plea agreement, they will have discussed those at great length with their attorney. They have to sign not only the final page of the plea agreement, they have to initial every page of the plea agreement that indicates that they read the page and understood the page before they sign it. And so we talk about the constitutional rights that they will waive, but they've already read it. Occasionally, we will have change of plea hearings. We call these open pleas, when there is not a written plea agreement. And there's a lot of different reasons why folks do that. I think I handled federal criminal cases when I was in practice for about 17 years. And I only had a couple open plea agreements or open plea changes. Most of the time there's a written plea agreement. But if there's not, then it's even more important that the court discuss the constitutional rights they will waive, because they don't have it written in front of them. And sometimes their attorney will file sort of a waiver of constitutional rights, and it's just a document that the attorney would create. It would list out pretty much all the same paragraphs you would have in a plea agreement, and then they have the person sign that. But not everybody does that. So I, in a change of plea hearing, advise them of their rights, their right to have a trial, their right to remain silent, their right to have an attorney, their right to confront witnesses. So if the government, is going to call a witness to testify and evidence comes in through that witness, the defendant has the right to confront that witness, and they're losing that right, waiving that right, if they enter a guilty plea instead of going to trial. So I need to ensure that that person knows of all of that before they change their plea, because at the base level, we can only take changes of plea if they are knowing and voluntary. And really what that means is that they're not being coerced into doing it, and they are going into it with their eyes wide open. They know of all the risks of going to trial. They know the benefits of going to trial. They know the risks and benefits, that associated with a plea. And with all of that knowledge, they're deciding to go one way, which is entering a guilty plea. So we have to ensure on the record, of course, that we're satisfied that the person is changing their plea in a knowing and voluntary manner. So that's really, I guess I hadn't thought about it like that before, maybe, but that really is the Constitution in action literally every day, because we do these hearings literally every day in courthouses throughout the state. And of course, that happens at the state court level as well. I mean, we have different procedures. We follow different procedures in federal court than they do in state court. On in the criminal cases, at least. In civil, we're a little bit more similar, but the state has to ensure as well that constitutional rights are made known to the defendant, and that the defendant, before they waive those rights, knows what they are. So that's something that's really important in all levels of courts.
Yeah, criminal proceedings for sure are really heavy on the individual constitutional rights.
Very.
Like you
Yeah.
mentioned, the right to counsel, the right to remain silent, the right to a trial, the right to a trial by your peers, all that, all those are really heavily based in the Constitution.
They are.
But so when we were going through like the substantive due process and the procedural due process, those are constitutional ideas or claims. And you mentioned that you do the criminal stuff every day, right? And that's really common. We have a lot of that in state court and in federal court. But how often do you see those constitutional claims about the state actors, the substantive due process, the equal protection? What are the numbers that you see of those in front of you?
I would say, and I'll get that question in just a second. I would say that the primary types of cases that we see involving constitutional claims are 1983 claims. I mean, I've been on the bench 6 years, and I have had claims involving, equal protection, and substantive due process, procedural due process. I think those, maybe are not as frequent, and it tends to follow a legislative session, because, I mean, most of the time, if a law has been on the books for many, many, many years, unless there's something new, generally those issues have been determined already. But when there's new legislation or something like that, or, an order or something that comes out that changes things, that tends to be when we see those. So the question, but like 1983 claims, I get those all the time. There is a very active prisoner pro se litigation. And what prisoner pro se means is folks who are incarcerated and they don't have lawyers, because you are entitled and required to have a lawyer in a criminal case because your liberty interest is at stake. In civil cases, there is no right to have counsel or have an attorney appointed. So most of the litigation involving, and not all, but most of the litigation involving prison conditions, for example, things like that, are pro se, meaning they're representing themselves. And there's a pretty active section of litigation that we get there. So we get a lot of those. Lots of, I don't want to say lots, but when somebody's unhappy with something that occurred, and the person they're unhappy with is a state actor, if they can show that there was a right that was violated as well, it's, the 1983 is the real common way to do that. And another thing that I did not mention is, and this is not in the Constitution, it's in the legislation, but if you are successful in a 1983 claim, the government has to pay your attorney fees as well. So if you're kind of thinking, okay, I have these issues, I know I can bring a negligence claim, I think I can bring a 1983 claim. A big difference between a negligence claim and a 1983 claim is that in most in most situations in Montana, there are some exceptions for sure, but in most situations in Montana, you cannot receive attorney fees for just like a tort claim, so like negligence, things like that. So any recovery you have to pay your lawyer out of. So in a 1983 case, if you go to a jury trial and there's a recovery, you get whatever the jury awarded you, and then you ask the court to award attorney fees, and the court will do that in most situations. I mean, there's some guardrails there and have to be reasonable, and there's a whole analysis that the court has to go through, but that's a key distinction as well. So let me hit that question. If in civil court, parties can appeal a magistrate decision to a district court, why do it? So we don't actually do that anymore. And that was one change that we made. And I think you're referring to the F&R process, the findings and recommendation. So in civil cases before, if a case was assigned to me and the parties did not consent, it would be assigned to a district court judge, but then they would refer it back to me, and I would handle it all on what we call a findings and recommendation, which is, I'd handle the entire motion practice. And then if they didn't like it, they could object to the district court. We changed our consent process in July of 2024. We used to be an opt-in, and now we're an opt-out. And so now the way our case assignment works is that cases are assigned to me. If they don't consent to me, it just goes to an Article 3 judge and he handles the case. If they consent to me, I just keep the whole case. So we don't have that sort of internal F&R process anymore. There's some holdovers because some cases have been around a little bit of time. And so, there are some, I think I have maybe a few left, but primarily now there's no F&R process in the civil setting.
So you're talking to us from your office, it looks like, or I'm assuming that's your
I
office.
am.
Unless you have
Yeah.
a very clean looking dining room.
No. And there would be a dog running around and all that as well.
Totally
Yeah,
get that. But so if you're working in your office, how are the federal courts dealing with the shutdown of the federal government?
that's a good question. So we are essential. And so we are able to do our accepted EXCEPTED functions. So basically, if it relates to our constitutional mandate, which is running courts, then we are able to do things. So we are open, and we're in phase 2 now. We have a phase 2 plan, and there will be furloughs, and there's certain plans for the like quick court staff, probation, things like that. Chambers, we have the ability to determine how we do that, if people are not coming in. But for the most part, we're conducting business as usual. Another distinction between federal and state, at least in Montana, is that the Federal Speedy Trial Act is very fast. It's 70 days from the initial appearance to the trial. And in Montana, and I did not practice criminal law in Montana, so I could be incorrect on this, but I think it's reasonable. And generally, what's reasonable is around 6 months. And there are things that can prolong both of those, obviously. But we have what we call a rocket docket in terms of the criminal docket in federal court. So, we're not going to say, well, we're just going to suspend your right to a speedy trial because we're shut down. We don't have the ability, that it does not happen during a shutdown. So federal criminal trials are going to proceed as normal. And we're just going to continue working.
Well, we appreciate that. I realize it's 7:32, so if folks need to log off, but we have one more question.
Sure.
And that was talking, when we were discussing like the criminal and the heavy side of the constitutional, that's the Constitution enact every day. We had a question, why do you think so many criminal cases are resolved by plea bargains instead of going to trial? That's a big question, but
Yeah. Well, there's a lot of risk in going to trial. One thing that we see commonly in our plea agreements in federal court, and again, I can't, because I didn't practice criminal law in state court, I can't speak at all to their process for pleas, but in federal court, if, let's say in an indictment, you have 3 or 4 charges, the plea agreement often will say, I'm going to plead to count 1 And then there's a provision in the plea agreement that calls for the dismissal of counts 2 and 3 at the time of sentencing. So you get rid of some of those claims and that could affect your sentence. Also in plea agreements, there's usually, and this is really getting into the weeds, but in the federal court, we have sentencing guidelines. They're not mandatory. They are they have to be considered, but they are not mandatory. But you have to calculate and consider the guidelines. And one of the benefits of a plea agreement is there's almost always a paragraph where the US agrees, and it has to be from the US, to recommend a decrease in your offense level. So the higher your offense level, the higher your guidelines are going to be. So there's a benefit to getting those points off of your offense level as well. So, and I think those are sort of some of the issues that go into it. And, I can say this from as a lawyer, not as a judge, but, sitting down and talking with folks and going through all the discovery in the case. And, it's a very difficult time for the person. And it's really hard to get your head around what the future looks like. And so, the plea agreement process, it takes some of the uncertainty out of it. And it's maybe cold comfort because you're pleading guilty to a federal crime and there's going to be some significant consequences that come with that. But on some level, it's a little bit of autonomy in a situation where there's not a lot. And that may be part of it. I think everyone's a little different, every individual, but.
For sure. Yeah, no, that makes sense. Well, I think we got to all of our questions. Thanks for your patience on that. And to anybody that's still hanging on, just please remember that we've got still, I think, 3 or 4 more Citizens Law School episodes coming up. So we're going through November 19th. And I think Judge DeSoto mentioned it, that we have a separate talk set aside just for Montana constitutional law, which is really interesting because Judge DeSoto has been talking about the federal constitution, and the Montana constitution is similar, but it's its own cool world in and of itself.
Very.
So that's coming up on November 19th with Constance Van Clay, who teaches Montana con law over at the law school. So she's going to have a great presentation on that, I'm sure. So thanks all for joining and hanging in with us. And thanks again to Judge DeSoto for volunteering your time. Super
My
interesting
pleasure. Thank you
stuff.
for having me. Appreciate it.
Thanks, everybody. Have a good night.